Good afternoon, and thank you for joining us. I'm Rebecca Pezzutti, the Legal Practice Director at IRiQ Law, and joining me today is my colleague, Riaan Hanekom. He's co-presenting with me today, and I'm delighted to welcome all of you joining us online today. Let me start by acknowledging the traditional owners of the lands on which we meet. For me and Riaan here in Brisbane, it is Meanjin, the Jagera and Turrbal people. Okay, so welcome to our presentation on preparing for your unfair dismissal and general protections conference. In terms of housekeeping, just a note to let you know that we are recording today's webinar. We'll supply the slides and access to the recording post-event. So you are muted and off camera, but you are welcome to ask questions. And we encourage you to do that as we go through the discussion today. You can ask questions by using the Q&A function or the chat function. Riaan and I will be monitoring that to make sure that you get an answer throughout the course of the discussion or before we close. And because we're lawyers, today's webinar does come with a general disclaimer that we're providing general information, not legal advice. Of course, if you have specific scenarios or workplace concerns within your organisation, we're here to help and can provide legal advice. So just reach out via one of our channels. In terms of today's agenda, we do have a lot to cover, and I'd like to make the most of the time we have, so we'll get straight into it. So we already know that applications in the Fair Work Commission are a readily available remedy for unhappy former employees. They're cheap to lodge. There are generally no barriers to entry in terms of filing an application and making allegations. We hear about high-profile matters frequently in the media, often wrongly reported as unfair dismissal claims, and creating some false expectations for employees and applicants around what's actually achievable in this jurisdiction. It's happening to many employers, and no doubt you're seeing these applications come across your desk more frequently than you'd prefer. The fact is that there's very little that an employer or an organisation can do to ensure that they're not on the receiving end of an unmeritorious claim. But there is plenty that can be done to mitigate risk and to resist those claims, both before and when they do arrive. On a side note, one of the things I do not advocate is presenting departing employees with a deed of release as a matter of course, even for high value and high risk senior departures. I know that some do, and the thinking behind that is that if you can get an employee to sign off on a deed as a preemptive measure, it's a good thing to achieve certainty. However, more often than not, I find this approach, or in my view, this approach, if you take it as a matter of course, creates two problems. The first is the expectation that employees can put their hand out on the way out. After all, people talk, and employees will learn inevitably that an offer of money in exchange for a deed might be made in relation to a difficult termination decision or one that's being strongly resisted by them. The second is that those employees will inevitably be prompted to go off and seek advice before signing that deed. And so you've prompted them to seek legal advice about their dismissal in circumstances where they might not otherwise have done that. And I'm yet to meet an applicant lawyer or paid agent who can fail to identify a cause for complaint arising from a termination, regardless of merits. So the trade-off in those circumstances is certainty, and I understand the desire for that from an organisational point of view. The questions, I think, from an overall strategic point of view for organisations become, what ultimately does that cost the business over time? How much are you prepared to pay for it? And can you live without it if your decision-making is defensible? And you're already investing in de-risking your dismissal decisions. And so you've got to think about whether you're giving yourself adequate opportunity to get a return on that investment. because that investment pays off and puts you in the best possible position to defend your decisions against successful challenge. Bearing in mind that unsuccessful challenge attempts are probably going to be par for the course. Informing that observation is data produced and published by the Fair Work Commission. Now that puts this into perspective and supports the proposition that employers have more to gain by resisting unmeritorious claims than they do by or from achieving early settlement and certainty. So let's take a look. So what you're seeing here is some data that's been published by the Fair Work Commission for the financial year 24-25. The data hasn't been published since 30 June 2025, but for the preceding financial year, the workload of the Commission in terms of the applications before it overall was 44,075. Of that, unfair dismissal, 16,500, and GP just over 6,200. The President of the Fair Work Commission, in recent public statements that he made, has indicated that this year the GP filing numbers are expected to be over 8,000. And we'll talk a bit more when we get to GP claims about what's driving that. But in any event, it's becoming a significant proportion of the Fair Work Commission's workload. The Fair Work Commission ceased reporting on median compensation in 2023, but then it was around $7,797, which was approximately 7 weeks' pay, where awards were made. And I think the takeaway really is that proportional to the number of cases that are being filed and the costs of this jurisdiction, the awards are relatively modest, and that affects both parties equally when you're thinking about the commerciality of conducting litigation in the Fair Work Commission. But let's take a look at what at least the Q4 2025 numbers can tell us, and perhaps some insights into what happens in the Commission. If we look at finalised numbers in the unfair dismissal stream, we've got the vast majority of those matters that were finalised in Q4 were finalised through settlement in terms of the unfair dismissal matters. So overwhelmingly, more than 90% are settling, where both parties agree that they'd prefer to do that than run the risk of litigation. But of those who did run the risk of litigation, 324 cases in that quarter, only 39 of those were actually, if you're an applicant, successful. If you're an employer, the balance were successfully defended. So 258 applications that did proceed to a final determination by the Commission were dismissed on the basis that the applicant was unsuccessful, and the dismissal found fair. In the general protections stream, the figures, sorry about that, I flipped over. The figures around settlement numbers are unsurprising in the sense that that jurisdiction, that stream is one where applicants don't have their cases resolved in the Fair Work Commission. They'd need to make a further application in the Federal Circuit and Family Court of Australia, typically, or the Federal Court if it's a significant matter by way of complexity or financial value. So where we see 533 certificates issued under Section 369, that's really telling us that of the matters that were finalised in the general protections jurisdiction, that's the number of people who were in a position, applicants, where they had to decide if they were going to take the matter further. Again, public statements made by the President of the Fair Work Commission recently that around 80% of those applicants with a certificate in their hand, ready to take their GP claim to the Federal Circuit Court, never do. So those cases actually entirely fall away. If we, really wanted to, we could probably correlate, the data on certificates against the data on filings of Form 2 applications in the Federal Circuit Court, but I'm going to take the President of the Fair Work Commission's word for it on that. So the key takeaways here are that most claims settle or are withdrawn before a Commission decision. Only a small minority proceed to final decision, and an even smaller fraction are found to be unfair, typically under 10% of those decided on the merits. So if you're making an investment in making defensible decisions around termination of employment, by investing time, patience, effort, calling in expertise when required, then your return on that investment is likely to resound in a successful defence of an unfair dismissal or general protections claim, very broadly speaking. These become strategic considerations. What are your prospects of successfully defending the claim? And inevitably, you'll be getting advice about that, so you can go into a conference with a clear understanding of what are the risks of an adverse finding against you, what are the risks for the other side. With an individual applicant who may have legal representation or a paid agent representing them, they're throwing good money after bad, particularly in the unfair dismissal jurisdiction, if they're turning down offers of potentially something that looks like the median level of compensation. Inevitably, the costs begin to outweigh the benefits for applicants in this jurisdiction. And it's not unusual in those cases where there's a valid reason for dismissal, but the process was lacking, or there were some procedural failures that made it unfair, for those applicants to actually see very little to nothing in a financial sense as a consequence of what becomes an empiric victory around, yes, it was unfair, but by the way, you're not getting compensation because you deserved it. And if you'd been given the full procedure, it probably wouldn't have changed things. And of course, individuals run the risk of reputational harm. And inevitably, they're weighing that up when they're deciding, particularly in the general protections jurisdiction, to proceed in the Federal Circuit Court or the Federal Court. We know most claims fall away. And so the other side to that coin for employers and organisations is, what are the implications of getting a reputation as a soft target or a frequent settler? And that does happen. We've seen clients, people have come to us, and unfortunately behind them there's a legacy of payouts, and it's very difficult to dissuade employees from their expectations, even if they're unreasonable, where that happens. And sometimes advocates who are that employer becomes known to the advocate, and there's an expectation that in response to a claim, the employer is going to part with some money just to make it go away. So let's explore how that looks in practice in terms of responding to unfair dismissal claims. And I'll hand over to you, Riaan.
Thank you, Rebecca. Yeah, just to serve as a bit of a guide to frame the rest of the conversation around, as we've mentioned, today's discussion is broadly speaking about unfair dismissals and then general protections involving dismissal. Now, these are the two main pathways that applicants will try and pursue dismissals or remedies for dismissals in. There is a distant cousin called unlawful terminations, but we'll leave that maybe for a note at the end. But essentially, the main difference between the two streams are sort of highlighted here on the screen, but it's the primary question in both differs. So for unfair dismissals, the Commission is considering whether the dismissal was harsh, unjust, or unreasonable. And there's a variety of factors that go into a determination that the Commission will make in that regard. So, for example, was there a valid reason relating to conduct or capacity? Was the employee notified of that reason? Were they given an opportunity to respond, etc.? Whereas in general protections, it's the question is primarily was the employee dismissed because of a prohibited reason, such as exercising a workplace right, engaging in industrial activity, or because of a protected attribute. The focus, therefore, for each of the two different pathways differs. And importantly, with general protections claims, and we'll sort of touch on this a bit more later under the risk when we consider the risks, but with general protections, the law imposes a reverse onus. So once an employee alleges they were terminated because of a prohibited reason, the law presumes that that was the reason, and then the burden shifts to the employer to disprove or to prove that there was a proper reason behind the dismissal. Now, a further difference is who has the benefit of the remedy or of the application rather. So for unfair dismissals or let me put it this way, general protections involving dismissals, any employee who has been dismissed, regardless of their income, their length of service or seniority, is able to apply. But with unfair dismissals, it's only employees who are able to apply, and that's, for example, employees who have met the minimum period of service, which is 6 months for most businesses, it's 12 months for small businesses, and it's employees who earn below the high income threshold. Another key difference is the remedies that are available. So with unfair dismissal, reinstatement is the first remedy that's considered. It's only if reinstatement is inappropriate, and there's a variety of circumstances where reinstatement might be inappropriate, such as where there's been a loss of trust or confidence between the employer and the employee, that compensation will be considered. Now, compensation is capped at the lesser of either 26 weeks remuneration or half of the high income threshold. The high income threshold at the moment is around $180,000 and some change. Another important difference, and Rebecca touched on this a moment ago, but is who the actual party is that resolves the matter. So for unfair dismissals and for general protections at least, the first port of call would be a conciliation conference held by the Commission. For unfair dismissals, if it's not resolved at a conciliation, the Commission can arbitrate the matter and will arbitrate the matter and make a binding decision. The same isn't true for general protections. With general protections, the Commission will hold a conciliation conference, but if the matter isn't resolved there, as Rebecca mentioned earlier, the Commission issues a certificate, and it's up to the employee then to decide whether or not they want to pursue the matter in the Federal Circuit and Family Court of Australia or in the Federal Court. The Commission will only arbitrate general protections involving dismissal claim if the parties agree to it. So if there's no agreement between the parties, then that's the end of the matter there, at least as far as the Fair Work Commission is involved. So we'll just briefly touch on some similarities between or some common features between the pathways. We noted how they may differ. But first example, they're both relatively cheap, especially compared to what the employees might be claiming. $89.70 is not a lot of money to pay. And as Rebecca mentioned, there's generally no bar to submitting an application. Whether that application has merits or not is obviously a separate question. Another point of commonality, all require a termination at law, and we'll discuss that a little bit later. The matters also commenced in the Fair Work Commission with a conciliation conference, and then depending on the relevant stream, it'll take its own pathway after that. Importantly, costs tend to increase after the initial conciliation conference. It may be that parties are engaging legal advice. If the employee in general protections involving dismissal elects to apply in the Federal Circuit and Family Court of Australia, all of a sudden you're in court and you're representing or defending a claim in court, which has its own costs as well. Lastly, generally speaking, the Fair Commission is a costs-neutral jurisdiction, which means that parties typically bear their own costs. There are some exceptions, and there was a recent decision where a clearly unmeritorious claim was lodged, unfair dismissal application. The employee it was well established that they were earning above the high income threshold, which excluded them from the protection of the general or unfair dismissal pathway. And in that case, the Commission ended up awarding costs of around $18,000 against the employee for bringing a claim that was, on the face of it, clearly unmeritorious. So, as I mentioned, generally, parties bear their own costs, but some exceptions do apply. Just moving along, if you've ever asked a lawyer a simple question, and I'll note there that there is no real thing such as a simple question, but if you've ever asked a lawyer a simple question, they would have given you the typical answer of, well, it'll depend. And that is somewhat of a joke in the profession, but it is true. And these are some of the reasons why. So if the question is, are we dealing with a defensible dismissal, particularly from the perspective of the employer? These are some of the considerations, and of course every case will turn on its own facts, and every case will have its own considerations. But generally speaking, some of the questions we'd ask is, was the application filed within 21 days? The Commission is very strict in applying its the 21 days timeframe from the date of dismissal for the applicant to lodge their claim. Does an enterprise agreement apply? Is another consideration. Does the employee earn above the high income threshold? Another important consideration, and the reason why we consider the differences between the two pathways is with a general protections involving dismissal, there's a reverse onus that applies, which really in general, you should have good documentation and appropriately documented and a fair process. But especially with general protections, all of a sudden the risk of non-persuasion is on the employer. So that just informs some of the considerations and some of the approaches we take. Another thing to note is what's the appetite for settlement? Is there a appetite from the employer's perspective to resolve the matter quickly and quietly, or is it was the process so defensible and so are we so confident that there is no real reason or no real incentive for the employer to try and settle the matter outside of a hearing? I think another just final consideration there is costs. As we mentioned earlier, generally speaking, it's a cost. The Fair Commission is a cost-neutral jurisdiction. But if the employee who has lodged a claim is represented by a paid agent, even in the event that there would be some settlement proposed, much of that settlement money is likely going to go towards covering the fees for the paid agent. So as Rebecca mentioned, it might be a case of throwing good money after bad. But in saying that, I think we're well placed to move on to unfair dismissals. I think for now I'm going to hand back over to Rebecca to kick us off there. Oh, you're just muted, Rebecca.
Thanks, Riaan. Okay, we did have a question too from Sarah. Thank you, or Sarah probably. Thanks for submitting that question. Just to seek clarification that can an employee submit a GP claim during their probation period? Yes, the answer is yes. We'll come to GP claims in a little bit more detail, but the crux of a general protections claim is that the employer took adverse action because the employee either had or exercised a workplace right, or for some other prohibited reason, which might, for example, include a discriminatory reason. Now, if they believe that their probation termination on the grounds of probation is just a front for some other prohibited reason, they would bring that general protections application. So there's no time limit in terms of the length of service for a GP claim, in the same way that there is for an unfair dismissal claim. And it is a common pitfall for employers that they do sometimes fall into, around believing that decisions they make during the probation period are free in all respects from any criticism or prospect of a claim arising. And so sometimes the attention isn't paid to things like working through your reasoning process, documentation and process, because you think that decision is out of reach of the Commission when it's actually not. So it's a great question. Thank you for asking it. Okay, and keep those coming through on the chat or through the Q&A function if you've got any questions. All right, so moving on then, we're going to look at some Fair Work Commission decisions. Sarah's got another question for us. I'll deal with that. Are there any stats on how successful the GP claim is if submitted? Not necessarily, because each case is going to turn on its own facts. So it would just fall into the bundle of all GP claims as far as statistics go, whether it was settled, whether a 369 certificate was issued. That person would have to go off and litigate in the federal court if they didn't achieve settlement in the Fair Work Commission. Okay, so we're going to look at the Fair Work Commission decisions and some lessons that can be taken from those that exemplify both employer best practice when it comes to decision making, because after all, employers do win a large proportion of the cases that go to a contested arbitration. But we'll also look at some that provide a cautionary tale, and there are obviously plenty of those that you hear about, because these sessions are often in the vein of, hey, look what went wrong, this could happen to you, don't let you be the next case example. What we're saying today is actually you can put yourself in a really good position, and there are some good case examples of where employers have successfully defended these cases. We'll look at the most common issues arising in unfair dismissal matters, namely jurisdictional objections, particularly where the question in issue is, was there even a dismissal, or was it instead a resignation or some other manner in which the employment was terminated that doesn't qualify as a dismissal at law? We'll look at redundancy and redeployment obligations, because since the decision in Helensburgh Coal, which we'll talk about, there's been some significant change to the expectations of employers around redeployment. We'll look at valid reason. The primary feature of the unfair dismissal jurisdiction for an employer is establishing that what they say happened did happen, that they have a valid reason as a matter of fact, and a fair process around conduct and performance. The Fair Work Commission, in some cases, balances all of the circumstances to achieve a fair outcome, and so we'll also consider how that looks through some of the cases. Thanks, Riaan.
Thanks, Rebecca. So as we mentioned earlier, a common feature between both pathways is that there be a termination or a dismissal to begin with, and that might seem like something that isn't an issue all that much. And when it's not an issue, it is pretty simple. But when it is an issue, it can be pretty complex. So what had happened in this case is that the applicant, so the case that we've got on the screen there is the appeal decision, but the initial decision concerned where the employer had some performance concerns about the employee. The employee was employed in quite a senior role, and the employer formed the opinion that the employee just wasn't cutting the mustard. They had a meeting with the employee. The employee was scheduled to take some pre-planned leave, and the employer had a meeting with the employee, and they sort of discussed this idea of a managed exit, but that really was the only option available to the employee from that discussion. The Commissioner then, in reviewing the decision, coming to its decision, and the initial decision was confirmed on appeal, but the employer tried to say that the employee was never dismissed. The employee resigned. Now, this was brought in the context of a general protections dismissal, but the principles of whether there was a termination or not do still remain. Now, the Commission applied an objective test, which was whether the employer's conduct was intended to bring the employment to an end, or whether it had the probable result, and whether the employee had any real choice in the matter. The Commission found that on the objective circumstances, the employer's conduct was intended to bring the employment to an end. The employer made a statement during the meeting that there was no future for the employee and that they were therefore pursuing a sort of a managed resignation. And that negotiation left the employee with no real alternative but to resign. And just briefly, in the words of the Deputy President, the choice that the employee exercised involved no realistic counterfactual, whereby, absent exercising that choice, the employee could reasonably expect to continue to be lawfully employed. And so ultimately the jurisdictional objection was dismissed, and the resignation was characterized as a forced resignation under the Act. And just as I mentioned earlier, this decision was confirmed on appeal. It's, as I mentioned earlier, in some instances, it's really not an issue whether the termination or resignation was forced. For example, in cases where an employer just does not pay the salary of an employee or only pays half of the salary of the employee for a protracted period, it's less likely to be an issue, and it's more readily established that the employer brought about the termination of the employee, even though it might be said to have been a resignation. Just moving along. If it would just play. There we go. In the context of labour hire dismissals, it's become really important where the host engagement for the contractor has ended. If the onus is more and more becoming clearer that it's on the employer, it's for the employer to establish that the employment is still ongoing. So in instances where the host assignment has ended, it's very important that the employer doesn't, or that the employer does, reach out to the employee and make sure that they are demonstrating efforts to offer redeployment. And that'll be highly relevant to where an employee brings a claim that they have been, that where their host engagement has ended, that they've been subsequently dismissed because there has been no other work available for them. Just want to make sure that I've got everything there. All right, Rebecca, I think you were going to say something about the case of the previous year.
Last year. Yeah, thanks, Riaan. I will. I'll just backtrack to labour hire as well, just to perhaps make the point that labour hire is often used as a means by employers, as a means to de-risk some of, well, all of the aspects of the employment relationship, including termination. So labour hire employees are often, off on, you can turn the tap on when you've got lots of work on, turn it off when you don't, and you don't have all of this dismissal risk. But what we're finding through the way that the decisions are panning out is that ending an assignment may also be treated as the end of employment, and that's certainly not the intention of the way labour hire is used. So something to be careful about if you are in the labour hire space or if you're using labour hire, because in the context of general protections proceedings, you can be accessorially liable for a dismissal. So I'll leave that there. It is an interesting development in labour hire, and I think could probably have a separate discussion on that entirely. So Helensburgh, Cole and Bartley is a decision of the High Court from last year. I've no doubt that many on the webinar today have heard of it. may have read it. It did significantly change how the obligations of employers when it comes to redundancy and redeployment are characterised. But I think you've got to keep this in perspective too. This is a case of a bunch of employees who were being made redundant, and an employee who said, who made an unfair dismissal claim in the Fair Work Commission. So this started as an unfair dismissal claim by an employee and became a High Court decision. Ultimately, the employee's unfair dismissal claim was premised on the argument that he could have been redeployed to work that external contractors were doing. And so this is also highly relevant in labour hire and contingent labour contexts. And that was defended by Helensburgh Coal clearly all the way to the High Court on the basis that there was there's previously never been any authority for the proposition that the requirement under the Fair Work Act to redeploy an employee before you can genuinely treat them as redundant, that requirement has never extended to having to displace other workers, even if they were, for example, contingent labour hire or in this case contractors. What ultimately the High Court said in this case is that the requirement to redeploy, which is in section 3892 of the Fair Work Act, requires it to be reasonable in all the circumstances for the person to be redeployed, either within the employer's enterprise or the enterprise and of associated entity. And so the focus of the analysis here is whether it would have been reasonable in all the circumstances for a person to be redeployed within the employer's enterprise. In assessing the scope of that obligation to consider reasonable redeployment, the High Court said that redeployment isn't going to be limited, or that assessment isn't going to be limited to whether there's a vacant position. What the employee needs to look at is there work or a demand for work within the organisation, that is the enterprise or the associated entity, that could have been performed by the otherwise redundant employee. And so that obviously broadens the scope of the inquiry that an employer has to undertake when they assess whether an employee whose position has been made redundant, before they terminate, they need to consider, is there some other work or demand for work that you could do? And the notion of a demand for work is really getting at that contingent labour. Interestingly, in this case, Helensburgh Coal, as a matter of fact, the employee couldn't be redeployed to the contractor's role because they didn't have the right skills. They were genuinely skilled independent contractors. They didn't have the right skills and licenses. But the reason this case, they failed in defending this case, is because they couldn't demonstrate they'd considered whether it was reasonable. And so it was really all about, have you done what you're supposed to do, not would the practical consequence have actually been different if you'd done that? Because the answer here was no. The practical consequence wouldn't have been different. This is one of those cases where the applicants were ultimately successful in their unfair dismissal claim, but the remedy comes to nothing because the answer is, well, you wouldn't have been redeployed. But what we get along the way is this wonderful gift of a whole line of decisions ending in the High Court. And I think really where this takes employers and where this is important is for employers who use contingent labour, particularly labour hire, because if you've got a labour hire worker performing work in your organisation on one hand, and on the other hand, you've got an employee being made redundant who could otherwise be deployed into that role, this decision basically says you have to displace that contingent labour hire if that person could reasonably be redeployed into that role. at the very least, you've got to consider doing that and demonstrate you've considered doing that. But I think where there's no other barrier around, particular skills and other things, and it's really just about having a flexible workforce, and where the person who's being made redundant has the skills and ability to do that job, you've got to demonstrate that you've considered that, and it may follow that role has to be offered to them. That's a pretty big game changer for redundancy and redeployment, and one that we're seeing have a real impact on how we're advising our clients in relation to redundancy and redeployment. Okay, so moving on then to a further unfair dismissal, which I'll throw back to you, Riaan, to talk us through.
Thanks, Rebecca. Yes, so Section 387 of the Fair Work Act sets out the considerations and the factors that the Commission will take into account in assessing whether a dismissal is unfair. One thing I will note is the decisions, and we've got the citation up, generally the Fair Work Commission, not generally, invariably, the Commission does a really great job of setting out the reasons for the decision. And so I really do encourage anyone to read the decisions. They're written really well. And what's really interesting is the Commission will set out all the factors and how they apply the factors, and especially the weighting they give each of the factors set out in Section 387. So what happened in Goodsell and Sydney Trains, the employee tested positive for a prohibited drug in violation of the employer's drug and alcohol policy. And the employer had a zero tolerance approach on drug and alcohol. Importantly, based on prior authorities, and the Commission in the decision does go into this, based on the prior authorities that that Sydney Trains relied on, they would have been within their rights to terminate the employee. But on an assessment of all the factors in 387, and Section 387 does give the Commission quite a wide net to consider a variety of factors, but particularly Section 387H sets out anything else that the Commission determines as relevant, which really is a broad net. And importantly, what the Commission considered as particularly relevant in ensuring fairness here was the employee's lengthy and unblemished employment history, his cooperation with Sydney Trains in the investigation, his remorse, and he accepted liability for his actions. Very important in this decision, and on these facts, the employee didn't test positive for and there was nothing in evidence to suggest that the employee was intoxicated while at work. All the evidence pointed to the employee having used a drug in his personal time, and by the time that he had come to work, the drug it was still in his system, but it wasn't affecting his capacity anymore. Further on, another factor is that the employer's mind was closed in the disciplinary process to the employee continuing his employment. So the employer and the Commission found that the employer had already made up its mind that dismissal would be the only path going forward. And then another consideration was that that Sydney Trains failed to consider any option other than dismissal. So after weighing all the factors, the Commission concluded that while the policy breach was a valid reason for dismissal, the termination was nevertheless harsh and unreasonable. And if you'll recall to one of the earlier slides, the primary question the Commission is engaged with in unfair dismissals was the dismissal unreasonable, harsh, or unjust? And so when the Commission put all the circumstances together, the dismissal was found to be unfair, and the Commission ordered the reinstatement of the employee. So another thing to note is that this decision was also taken on appeal, and the full bench confirmed this decision on appeal. Moving on, in Comedy and Bureau Veritas, this decision is also very interesting because it once again shows that having a valid reason for dismissal, a dismissal can nevertheless be harsh or found to be harsh. So it's really important that when you're assessing whether dismissal will be fair or whether dismissal is the appropriate avenue, to try and take a step back as far as you can and assess whether dismissal really is the most appropriate pathway forward, especially considering that's what the commission will do. So in this instance, the employee, Mr. Carmody, he was working as a quality control officer for the employer, for Bureau Veritas. In January of 2024, there was an incident where he had amended certain data of a client, and he had cut and pasted information from one report into another, which invariably resulted in the report not being trustworthy. The employer offered counseling, and they directed him not to repeat that mistake. And then in August of 24, Mr. Carmody again failed to adequately quality control a report that had plainly incorrect information, and there was some concerns around fabrication of data. Mr. Carmody phrased it as manipulation of data. He had seen a report that, in his opinion, was clearly incorrect, and he had changed some of the data sets. The employer alleged that that was serious and willful misconduct. And ultimately, when the commission considered everything together, it was only Mr. Carmody was then summarily dismissed, and it was only the summary dismissal that was deemed to be unfair. Very likely, had the employer terminated Mr. Carmody with notice, the dismissal would have been held to be fair. But the commission found that because he was summarily dismissed, that rendered the dismissal as harsh. So there was a valid reason for dismissal because the employee had failed to exercise due care. But summary dismissal was rendered to be harsh. With that, I think I'll hand back over to Rebecca.
Okay, we've got a little bit of time left, and I want to. We don't have a great deal to discuss when it comes to general protections, but it's as far as the cases go. But there is a couple of things to know about what's happening in general protections. You might recall that at the outset I mentioned the data from the Fair Work Commission around general protections, and particularly the predictions of the President of the Commission is seeing an increase in those numbers of applications being filed. The Commission's own view, expressed publicly and in some of its published material, is that this increase is being driven primarily by paid agents who are diverting claims that might otherwise have been an unfair dismissal claim or application into the GP jurisdiction. And for those of you who aren't familiar, paid agents are non-lawyers who have the right to represent individuals in the Fair Work Commission. That's currently under review for because of some examples of really poor conduct and the absence of any regulations of paid agents at all. But putting that aside, they're driving this increase in numbers essentially as a means to bring a claim that would otherwise have gone nowhere because the employee either has an insufficient qualifying period. So to the question that Sarah asked earlier, if the employee hasn't served a minimum 6-month qualifying period in a large business or a non-small business, then they won't have access to unfair dismissal jurisdiction. And so paid agents are just diverting them to general protections as a matter of course, regardless of whether there is a basis for that type of claim to be made. And it's also accessing a broader range of remedies, including general damages style compensation, which isn't available in the unfair dismissal stream. So as a business model, paid agents are really diverting people who approach them for advice and representation into the general protection stream, and it's created real problems for the Commission as far as the workload of the Commission is concerned. So to address that issue, which is really about the misuse of the general protections jurisdiction, but also to manage the workload of the Commission, there have been changes to the procedures in place for how you apply and respond to general protections claims. So those changes include a new form which requires applicants to do more than just tick a box and say, yes, it's a Section 340 or a Section 351 breach, but they have to articulate the grounds of their claims with some precision. The Fair Work Commission will now also determine late applications on the papers. Previously, if somebody files a general protections application and it's out of time, it just goes straight through to the keeper. The employee gets a notice to say you've been served, and you have to raise a jurisdictional objection if you think it's out of time. Now, the Fair Work Commission registry and case management team will actually filter those through. So we're starting to see some of those appropriate and sensible barriers to entry coming into play. The other thing that's happening is that representation by lawyers and paid agents is being limited in what are considered straightforward general protections claims. You know, in and of themselves, they have some degree of complexity, but I suppose it's fair to say that some cases might be more straightforward than others. And so in those cases, the Commission will expect parties to self-represent, even including organisations, provided they've got some degree of HR or other leadership expertise that can warrant, you know, that person being required to represent. And the Commission is taking a very short shrift approach to general protections conferences, where formerly, you know, there might have been, you know, a bit of a shakedown attempt by paid agents. If the employer turns up and says, no, there's nothing to see here, we're not paying anything, we're here because we have to be, we're compelled to attend a conference, but we're not here with any money, by all means, we'll hear what they've got to say. We'll try and help them understand that this wasn't a conspiracy theory, or there was no nefarious, you know, activities on the part of the employer going on. You were just bad at your job, that kind of thing. But otherwise, the Commission will terminate the conference and basically not waste their time on it. And in those circumstances, you're looking back at those statistics that say that 80% of the people who leave those conferences with a 369 certificate don't take any further action. And so I think that's got to inform settlement strategy a little more than it has for employers in this space. So aside from those structural changes, which are creating some barriers to entry in the Fair Work Commission, the other key considerations for employers and organisations and what they can control is really around managing that decision making, because that's where you can do a lot of really good work in risk mitigation and ensuring that your decisions are defensible. There's a couple of things that we would routinely identify as really effective steps to mitigate that risk. The first is to limit who makes and contributes to the decision. Ideally, you should have one decision maker. In organisations that are larger, sometimes you might have somebody or a number of people who are collecting information and putting that, for example, together in a brief to the ultimate decision maker. But what you don't want is particularly like at a board or executive level, you know, the whole room making the decision. And the reason for that is that the general protections claims really all turn on what was the reason for the decision. Now, the evidence about reason for decision will be sourced from a number of places, well, from one place primarily, and that's the decision maker, what was in their mind, because the authority on this question is well settled and clear that it's really about what's in the mind of the decision maker, what was motivating them, what are the operative and substantive reasons for them taking the action that they did or making the decision that they did. And that person individually gives evidence about that. but their credibility is bolstered by all of the other things that are going on. And if the evidence of those things are well documented and consistent with the decision makers' evidence of what their reasons were, then they're more likely to be accepted as truthful. If there's lots of other things going on, or in some cases where they're saying one thing to the employee but then doing other things behind the scenes, that can be problematic. So one decision maker, evidence of reasons that's consistent with that decision maker's reasons. And you can quarantine known protected attributes or prohibited reasons. So you don't need to pretend that you don't know that so-and-so has, for example, the employee might be being dismissed because they are chronically underperforming and have been performance managed for a long time. The fact that they've got a carer's responsibility that's seen them being absent frequently in the, say, the recent past before you finally get to biting the bullet on a decision about termination, you don't have to ignore. You can quarantine that and put that squarely outside of the decision-making framework and be clear that that has not influenced your decision-making. Because the reverse onus in general protections matters effectively requires the employer to prove that the prohibited reason was not a reason for the decision, which on the face of it sounds a little daunting and overwhelming. And it has, good reason, but there has been a trend, whoops, getting ahead of ourselves here. There has been a trend in this jurisdiction for, particularly around high value executive departures, for applicants in this space to routinely pitch their expectations for outcomes in the multi-millions. This most recent decision in Technology One, this was a retrial after a successful appeal of an original 2019 decision, which did award $5.2 million in favour of the applicant. But this retrial decision is expected to really put the brakes on these expectations and influence this trajectory, and hopefully bring things back down much closer to earth as far as what these people, what employers, departing high value executives think that they're really worth when it comes to GP claims. We're getting short on time. I don't think we've got other questions, so I'll wrap up with a review of this decision because it is a good one for employers. It's a win for the employer in this case, and it ultimately turned on the court accepting the evidence of the decision maker, that the fact that the applicant in this case did have a mental health disorder and disability, and he had exercised a workplace right. He'd actually threatened legal proceedings against the employer, and he had other entitlements that were including incentive payments under his contract that were in contention. So all of these things were at play, but the court accepted the decision maker's evidence that the substantial and operative reason for the decision to make this employee, to terminate this employee was not because of any of those things or another prescribed reason. It was because of his performance. So the evidence of the decision maker in that case was bolstered, and the credibility of that evidence was bolstered by the contemporaneous records and documentation around issues with regard to performance. This is a case where the employee brought a significant claim for general damages, which is available in general protections matters, and that was said to arise from a serious psychiatric injury arising from termination, in the sense that he was so distressed. But the judge in this case makes a number of interesting observations about the personality type of this particular employee, that he was particularly dedicated to his work to the detriment of his private and personal life, and there were things that were distressing for him, but that didn't necessarily fall at the feet of the employer in circumstances where they acted lawfully, and the termination was always going to be distressing for this particular employee, and the employee found it difficult to accept that there were performance challenges. etc. So it's a good example of how a defence strategy, it requires leading the evidence from the decision maker of the steps taken against the employee during their employment and the reason that those steps were taken. And like I said, hopefully we'll have a fairly chilling effect on the expectations of claimant and claimant firms, because this particular individual was repped by a plaintiff law firm, I guess you could call them. That was from woe to go. So from the very outset, they were represented by Harmer's lawyers who saw it all the way through. And it may ultimately dampen some of the enthusiasm for this type of litigation, where the amounts of compensation sort of highly speculative. Particularly when you're talking about 55 million, he gets 5.2, and then that comes to nothing after a retrial. All right, so that's probably all I need to say about this particular case, and it wraps up our discussion about general protections on a positive note, I suppose, from the point of view of defensible decision making. I don't see any other questions in the chats or the Q&A, but if you have them, now's your opportunity to ask. Otherwise, we'll close by saying thanks for joining us. Appreciate you taking time out to hear from myself and the team. We hope that's been of value to you and within your organisation. We will share the slides and the presentation recording, so feel free to access that. And otherwise, you can stay in touch with us through all of our usual channels. Thanks again. See you later.